Energy Media readers, we have another story, another interview on the Wet'suwet'en blockade and the issue of Indigenous or Aboriginal title and Indigenous law. And for that, I'd like to introduce Professor Margot Young from the Allard School of Law at University of British Columbia. Welcome to the interview, Margot.
Thank you. It's a pleasure to join you.
Well, look, this is a very, very complex story, at least for those of us who are not steeped in Indigenous law and constitutional law. So we've been trying to sort it out for our readers. Could you, now there's been a bit of some kind of an agreement that's been agreed to by the BC government, the federal government, and the hereditary chiefs of the Wet'suwet'en. Could you just give us a very brief overview, just your take on it?
Sure, I'm happy to do that. So it's being referred to as a draft agreement. And I take that to mean a couple of things. That it's probably a process-focused agreement, that is agreement about the procedure to be followed with respect to Wet'suwet'en title and rights, and that it may also be a process that importantly includes an opportunity for the Wet'suwet'en people as a whole, with diverse opinions, in particular on the building of the pipeline, to come together and to have some larger discussion and process around it. I think it's also important to note what it isn't. It isn't an agreement that deals with the pipeline dispute.
Now, my takeaway, and you can correct me on this if I've got it wrong, but after the Delgamuukw decision in 1997 that recognized Aboriginal title, and after the Chilcotin decision in 2014, which I guess conferred or recognized is maybe the better word, the Chilcotin First Nations Aboriginal title to 1,700 square kilometers of land, there hasn't been a lot of resolution of outstanding issues to date. We have much to talk about and much to resolve in these discussions, as particularly in BC, with First Nations and unceded territory. Have I is that a good summary?
Yeah, I think it's a great summary. And one of the things that's a really shameful state right now is that in 1997, Delgamuukw noted that title was unextinguished and that there were existing Aboriginal land rights and title in BC. They weren't able to resolve it at the level of the Supreme Court because of some omissions in lower courts, and so it went back to negotiation. And since that time period, nothing's happened. And so there have been attempts, we're told, that the government made to try and get around and circumvent or resolve in an expedited way the issue of, in particular, Wet'suwet'en title, but those were unsuccessful, and we've basically ended up with the legacy of this government inaction over the dispute around Coastal GasLink and the Wet'suwet'en lands.
Now, you are a constitutional law scholar, and I've interviewed you a number of times before, so I know your opinion on a number of topics, but you have a take on in the Aboriginal title that I think my readers, particularly in Alberta, need to hear. So, and it's around the issue of consent. Please, if you can give us your take.
Okay, well, I'm hoping it's not just my take, but it seems to be the way that these issues are understood by a whole community of legal experts. And that is, first of all, we are constitutionally committed to meaningful consultation with Indigenous peoples, with Indigenous nations over their rights protected under Section 35 of the Constitution. And we are also committed at international law, and at least politically at international law, and politically domestically in terms of what our politicians have said federally, to the protections and the principles that are set out in the United Nations Declaration on the Rights of Indigenous People, UNDRIP. And UNDRIP makes it clear that development on the lands with respect to the traditional lands of Indigenous people is not to proceed without their consent, and that consent, to be meaningful, is free, prior, and informed. We also know that our own province, and you're talking to me in terms of an Albertan audience, but in BC, where I sit right now, actually on the lands of the Coast Salish peoples, our government has passed the UNDRIP Act, pledging to put into practice in its resource development, in its agreements with Indigenous people, those ideas of free, prior, and informed consent. So here's the interesting point, and I'm going to let you come back and ask me a bit more about that. People get exercised about the notion of free, prior, informed consent and worry, oh no, now Indigenous people just simply have a veto over the economic health of Canada, and that's not so.
Well, we've had this discussion, and I understand your point of view that if you're going to enshrine or recognize free, prior, informed consent, that has to acknowledge or has to incorporate the ability of the Indigenous community to say no to a project like a pipeline, and everyone accepts that.
Well, I think that's right. There are a couple of precursors to that ability to say no, and that is there's an obligation on the government to engage in a dialogue, in a discussion, in consultation. And I think there's probably a corresponding obligation on the part of Indigenous people to be responsive to that. That's what we haven't seen, by the way, in terms of the ongoing dispute up north in BC. There wasn't consultation, there wasn't nation-to-nation engagement, which the government rhetorically committed itself to and then didn't carry out in practice. So before we get to the point where vetoes might even become relevant, there has to be that kind of meaningful discussion, engagement, exchange of viewpoints. And importantly, the legal documents talk about consent. They don't talk about veto. It's a bit of a red herring, and it's kind of inflammatory to go right to that language.
Gotcha. In the reading that I've done on this, my understanding, and again, correct me if I'm wrong, Delgamuukw actually put some limits on Aboriginal title, and enabling the federal government to override, I guess, a no in the case for projects that are of public interest, the national interest. And UNDRIP, Section 46, I understand, also places some conditions on free informed consent. Have I got that right?
Yeah, you do. So you're talking in particular at the beginning of your comment about the way in which our courts have interpreted Section 35, which protects existing Aboriginal title and rights. And that section has been elaborated upon by the court to allow for the government on occasion to justify infringements of existing rights. But there are a set of parameters to that infringement that would make it legitimate under constitutional law. I think the larger point is, and by the way, there are a number of people, and I would put myself in that number, who are critical of the way in which the court has kind of undermined through articulating a doctrine of where the government can go ahead anyway, despite Indigenous objections and certain grounds, certain kinds of consultation. But the point is, nonetheless, that what our Constitution allows in terms of legitimate infringement can follow only upon meaningful consultation, and that the notion of free, prior, and informed consent to be at all meaningful, I would argue, has to mean sometimes Indigenous peoples get to say no. That's the whole point of consent. We don't have to sort of run hysterically off into the neighborhood of a veto, a veto, a veto, but we have to realize that for consent to be meaningful, you have to have a possibility of saying no.
Now, ever since Delgamuukw in '97, and basically my understanding is that the federal government has kind of abdicated its responsibilities here by trying to shoehorn the duty to consult under Section 35, shoehorn its responsibilities into the project review process, most notably pipelines, and kind of fob off its duties onto the companies as opposed to doing this themselves and doing a good job of it. But everything that I hear from First Nations, and I've grown up with First Nations back in the 60s and 70s and worked with them and for them in the 90s in Saskatchewan. And the thing that overrides everything is engagement and discussion and negotiation. They want face-to-face. They want to know that if there's a problem, an issue, that at the very least, they're going to have a fair conversation with the Crown. Is that fair?
Yeah, I think that's fair. And the point you make about the illegitimacy of the government delegating the responsibility to consult to corporate actors is a really valid one. part of what we've pledged to as a nation and as a province in terms of the, the phrase reconciliation is giving due respect and regard to Indigenous communities, Indigenous nations. And when they call for nation to nation consultation, that's their due. That's the kind of respect and acknowledgement we have to deliver to keep up to the terms of UNDRIP as we've pledged to implement it domestically at both the provincial in BC and the federal level across all of Canada. And so sending in, a company to check out, sending ministers, but not prime ministers or premiers, is not really doing the kind of nation-to-nation consultation that we've promised to do, at least in our talk. And so it's really disappointing that it's taken this long to have the kind of discussions that apparently have been going on for the last 4 to 5 days, out of which has come a draft agreement. It's really shameful that it's taken that long for this to happen, and that we've had to get to the point we've gotten to in terms of the protests across Canada to force governments just to follow through on what they say are their commitments.
Margot, one of the reasons why I enjoy interviewing you is because you have a point of view that I know is quite common in British Columbia, but is probably not well received in Alberta and Saskatchewan. And I think it's really important for my Alberta readers to actually hear that point of view, and from a constitutional scholar, even more so. So this is my last question, I guess, is how common is your take? And I know this is a little biased, the question I'm asking, but how common is your take on this issue in British Columbia?
Well, amongst the people with whom I circulate, or the groups I'm in at the university, civil society, I'm pretty mainstream. And what comes through my Twitter account is pretty much consonant with this idea that we failed Indigenous people historically, and we're failing them currently by not changing course in how we deal with them. So, from my perspective, I'm unexceptional in this viewpoint. But, we live in a society, right, where we have this siloed effect. And so I'm not in conversation a lot with people who have an opposite point of view. But I do think, nonetheless, these sorts of broadcasts are really important, that we share perspectives across the country, across provincial lines. And one of the things I think is pretty common is that people recognize we've done great injustice to Indigenous people over the course of settling from the European community, Turtle Island, this land we now call Canada, and that we have to change how we engage with Indigenous people. Their well-being has been neglected. There are astonishing levels of poverty, of low social welfare in First Nations community that are shameful in a country like Canada. And I think there's a fair sense across Canada that Canadians want to do right.
Margot, on that, we're going to end the interview, but I want to say that I do want to have you back. And I want to actually make a plug for something that I've been arguing for quite a number of years on Energy Media, and that is that these issues are never going to be resolved until Albertans, and not just Albertans, but the industry itself has to do a better job of engaging with Indigenous people within BC and engaging with British Columbians, because the political culture is very, very, very different here than it is in Alberta and it is in Calgary. And as somebody who has a foot in both provinces and claims dual citizenship these days, I can attest to that. And I think it's really important that we raise the awareness of how BC Indigenous communities see this issue. So I'm going to be calling on you again, because this issue is not going to be going away anytime soon.
I'm happy to talking. And I'd say one last thing, which is that I think there's a confluence of issues right now that has been really made clear by the Wet'suwet'en conflict. And that is environmentalism, a concern about our environment, about climate change, a concern about justice for Indigenous people, and general concerns about social justice and inequality of well-being within the Canadian population, within Canada, are all coming together in ways that make really forceful encounters between these opposing viewpoints you articulate. And so, having the Wet'suwet'en conflict to talk about gives us an opening into some of these other issues as well, and how they overlap, and how, you know, even within the province of British Columbia, there are different pockets of viewpoints from Metro Vancouver, which is where I live, and up north in rural BC. So I look forward to talking to you again.
Margot, thank you very much, and we will be in touch.